My name is Catherine Crowley. I'm the Real Estate Practice Development Manager at Womblebond Dickinson. I am delighted to be hosting a second webinar on e-signatures on behalf of the Association of Property Support Lawyers and the London Property Support Lawyers Group. Between us, we represent over 100 regional, national and international law firms undertaking a very mixed bag of commercial and residential work. We're 2 months into e-signatures. COVID-19 is still with us, sadly. This is a great opportunity to take stock and share our experiences. And we really appreciate everyone taking time out of busy days to support this webinar. We all want to see our industry thrive in what are undoubtedly difficult and unprecedented circumstances, and take its place in the digital age. So today's webinar is all about sharing our experiences to help achieve that vision. We have a panel of speakers again. First up, we have Barry Gross, a real estate partner at Bowen Leighton. But Brian Cave, Leighton Paisner, he's going to share his firm's success with e-signatures. I'm going to be looking at some of the issues we're experiencing with complying with the Land Registry's e-signature requirements. Next, we've got Tom Hubbard. He's PSL and Senior Associate at DWF Law. He's going to be talking about the challenges they have experienced rolling out using an e-signature platform, both internally and also some of the issues that their clients have had to consider. We then have Siobhan Hayes. She's a knowledge management counsel at Reed Smith. She's going to look at the bottom line and the costs associated with using e-signatures. We've then got Marcus Tofanello. He's head of knowledge management at Burkitt's. His firm has a very strong residential and commercial real estate practice, and he's going to be discussing the importance of choice of execution methods for their very varied clients. And then I'm really pleased to have Robin Malpas on the call. He is Deputy Director at HM Land Registry and author of many of the recent Land Registry blogs on e-signatures, and he's going to be sharing the Land Registry's sort of current vision for future use of e-signatures. So we are hoping that we will speak for about 35 minutes. Warren Gordon, who's a senior PSL at CMS, is then going to chair a 25-minute open forum session. So could I ask everybody to keep themselves on mute? It should be there in your control panel. It looks to me like an acorn, or alternatively, it is supposed to be a microphone. So if you could just check that you are turned off. I attended a webinar recently where the Hoover featured as strongly as the speaker. So let's try and avoid that for this one. And also, could you keep your questions until the open forum? So everybody on mute, and just to let you know, we are recording the session and we'll make the recording available as soon as we can. So over to you, Barry.
Thank you very much. And first of all, big thank you to the Land Registry for embracing the use of e-signatures, and that's a really heartfelt thank you. As someone who's wanted to be able to use e-signatures for a long time, both for Land Registry related transactions and other transactions, actually being able to use it is a huge step forward. And I think you cannot underestimate the significant positive impact that this change has had, because by the Land Registry embracing existing e-signing platforms, you have made e-signing legitimate. And I genuinely believe it is one of the largest steps forward for the profession since I began practicing quite a while ago. This is, in my mind, this is absolutely not just about some registrable dispositions. This is about the future of legal practice, and the Land Registry have played a huge role in moving that forward. It has definitely unlocked a latent appetite for e-signing. Previous concerns regarding e-signing not being good enough for the Land Registry were being interpreted as meaning it's not good enough. There's something wrong with e-signing. So now that the Land Registry turned around and said, yes, we will accept e-signing, it means clients are welcoming it. You have given it credibility, which is of huge value for all of us. Just thought it would be helpful to give a few examples of where we have used e-signing to give a flavour for how e-signing delivers massive efficiency benefits and massive overall improved satisfaction for clients, that's our clients, and ultimately the Land Registry's clients as well. So I've got three quick examples. The first was a bond substitution which involved 17 properties, and the overall signing pack for that bond substitution comprised around 250 documents. Of those 250 documents, 34 of them could not be e-signed for various reasons, but the rest could. The process for preparing the engrossments for the 34 non-e-signing documents took about 5 hours. For the 216 e-signing documents, it also took 5 hours, but obviously you're talking about or 6-7 times the volume of documents. Worse than that, the hard copies, when they came back, having gone out to be signed, when they came back, had mistakes in their signing in them. They had to be reissued due to the urgency. They had to be reissued by courier, and so there was additional cost and time lag there. The e-signing documents had, unsurprisingly, no mistakes in the signing. The hard copy documents took a few hours for the client to sign. The e-signing documents took under half an hour for the client to sign all of them. And the client and witnesses both expressed their huge gratitude for the fact that they only had 34 documents to sign by hand and not 250 documents, which would have left them with a very sore hand and really hating the whole process. So that's just one example, and I think that's unusual. Second example, acting for a large listed property company that had an urgent lease that had to be in place within 24 hours, but the key signatory was in Sweden, and without a form of e-signing, achieving this would have been impossible. So e-signing in this case was literally the difference between a deal happening and not happening. And finally, a large private landlord with hundreds of mixed-use assets where there's a high volume of shorter-term lettings, where there have been a level of nervousness around using e-signing, even where not registrable, and with the Land Registry saying that they were now accepting e-signing, the client has got a lot more comfortable to use e-signing, and they're doing 10 to 15 lettings a week. The process involved has been significantly shortened. It's a much better experience, especially for the smaller, often sole trader type tenants who may not use a lawyer that is close by to them for cost reasons, and so getting hard copy documents around is much more challenging. So being able to do it using a platform is a lot easier for them. But it's not just about the time savings that we've been making. There's massive sustainability improvements, which I think that the Land Registry should be proud to lay claim to. We no longer need to use couriers to send documents around at the last minute. There's no more need to print out documents, huge amounts of paper to be being saved, and no printing at all. There's also no scanning back, and so the end result is that your e-signed document is an easily searchable document as well, which I think has benefits for the lawyers, but also I imagine for the Land Registry too. There's far less power consumption that then becomes involved. It really is a digital revolution. I could probably go on for hours waxing lyrical about all the benefits of e-signing, but I will get into a lot of trouble if I did that. So I'm going to hand over to Tanya now to take the webinar forward.
Okay, thank you. I'm actually standing in for Tanya's day. It's Catherine. Thank you very much for that, Barry. Now, I am a huge fan of e-signatures. It is, however, a Thursday afternoon. I might struggle to match Barry's enthusiasm today. So thank you very much for that. The Land Registry requirements for e-signatures were, I have to say, more prescriptive than I had expected. However, the subsequent clarification on legal representation not being required for the donee of power of attorney has been hugely helpful for our clients. So thank you for keeping your practice guide live and developing it. Two-factor authentication for signatories isn't problematic. Many platforms have this functionality. It works well, and it's often something required by lenders, and what the lenders require, the market generally follows. What is proving problematic, however, is two-factor authentication for witnesses. It isn't required in the wet ink world, so many of us are struggling to understand the rationale for it. Despite the publicity being generated by some platforms, we have yet to see a proper solution. Treating a witness as a standard signatory isn't an acceptable solution for many platforms, because this results in the witness receiving a copy of the completed documents, and therefore, of course, that raises confidentiality issues. You could possibly turn off the auto receipt of completed documents for signatories for some platforms, but again, this isn't the answer, because by doing so, we turn off an efficient part of the workflow. Currently, I'm advising our lawyers and clients to avoid e-witnessed signatures, which is a real shame. Shutting down an option like that is never the best way to achieve engagement. The other requirement I'd like to highlight is the need for a conveyancer to nominate signatories. Now, our clients, whether they're developers, social housing providers, etc., they want to concentrate on their core business, and that is property. They want to get the deal right, and once they've thrashed out the terms and got internal sign-off on that deal, you might be surprised to hear that actually signing the transfer is regarded as admin, and it's certainly not something they want to spend lots of time on, as Barry touched on earlier. What they would like to do is have the flexibility to allocate a signatory on the day, as they would for a wet ink signature, and not in advance when the lawyer sends out the electronic envelope. Obviously, this isn't allowed as a result of the Land Registry requirements, although there is functionality for a specified recipient later on in the envelope workflow, but obviously we can't use that. So I really hope you would be able to relook at that aspect of the requirements. And my final flag, concern is what happens if, despite the best efforts, the Land Registry requirements haven't been met. So for an electronic envelope with multiple signatories and perhaps multiple witnesses, what happens if one witness out of several did not have two-factor authentication applied? What happens to that transfer? The law says it is legally binding, and perhaps millions of pounds have been paid over on the back of it, but it's not going to be accepted for registration by the Land Registry. So please, could you consider extending your guidance to cover this scenario? And I don't think the answer is rectification. In the eyes of the law, there is nothing to rectify. I really do think we need this certainty to boost confidence in e-signatures. It's very much a new phenomenon within the real estate world, and lawyers just want to know that like most things in life, if you make a small mistake, the world is not going to end, and it can be remedied in some way. So I really do think the Land Registry needs to find a way to allow registration in that sort of environment to proceed. So without further ado, over to Tom Hubbard.
Hi, so I'd like to talk for a few minutes about the challenges posed in the sort of operational sphere of e-signatures. In the last few weeks, I've been involved in setting up a team of fee earners to service a major client, really to adopt an e-signature in place of the Mercury process. Now, this client signs many hundreds of documents each year, and obviously Mercury poses an administrative problem because there are essentially teams of paralegals at the client end who spend their days printing and scanning documents to no avail, as far as I can see. And so this process has flagged the various issues associated with adoption of an e-signature platform in this setting, and the potential hurdles. Now, obviously, again, as with Barry and Catherine, I'm a big fan of this process. I think in the long run, it will be great. It will make everybody's lives easier. It will increase transaction speed, and particularly importantly, it means we are not touching paper documents. So we in the current public health crisis, it's really important. So the first thing is obviously we need to establish clear workflows dealing with the use of e-signatures amongst our fee earners. And I would highlight that this is entirely a new area of practice, so we need really simple and transparent workflows that will enable our fee earners to assimilate this entirely new experience. This is, at the end of the day, this is totally new to them in many cases. And we have to provide clear guidance as to the technical steps, how to upload a document for signature, how to mark it up, how to date and complete, and then explore also the circumstances and document types where an e-signature can be used. And certainly in my experience, the initial, certainly in the early days, we will tend towards simple client-side execution only, and potentially avoiding e-signatures in more complex scenarios in some cases. And then how do we deal with other firms, particularly the need to notify them of any proposed use of e-signature and agreeing a signing order, which with more complicated transactions can actually become a significant technical step, which involves lots of, some fair degree of back and forth and agreeing specifically the steps to be taken within the electronic envelope. Now, in my experience, that some of these can be distilled into a briefing note a few pages long, but the complexity does escalate significantly. And the underlying technical detail is potentially a major stumbling block. Now, I do get accused of being long-winded. In my case, my master e-signature guide is over 100 pages long. The APSL, Catherine has managed to distill it to 31 pages. Fee earners cannot be expected to assimilate this sort of information overnight. My take is there's at least a 2 or 3 month lead in where fee earners are getting to grips with this process. So there's quite a lot of work to do to make sure that fee earners are brought on board in the right way and in a way that reflects the kind of risk associated with this, because as Catherine said, we don't want to see transactions stranded because we can't register because of an inappropriate use of an e-signature. So there's quite a lot of setup to do to make sure that this all pans out well in the long run. And also, we should understand that there are quite a few areas where a settled approach has been yet to be established. For example, contracting out of the 1954 Act involves making stat decks. E-signatures aren't really common practice in that setting, and the requirements of many institutional lenders have yet to fully emerge. So there are a series of factors that operate as disincentives to adoption that need to be overcome. And we've also got to deal with, making sure the precedents are adopted to accept the requirements for e-signatures, formatting. There's all sorts of practical things, down to the simplest things of, making sure that a document is converted into a PDF with plans and the plans are all at the right scale. People need to learn how to use things like PDF split and merge. So fee earners are in a position where they have lots of information to assimilate, and there is to some extent, I'm calling it login fatigue. People have to adopt a new process. The psychology of their work and their work pressure means that this is actually potentially quite a significant hurdle. So there's lots of work to do to get our fee earners on board. And I think, as I say, I think this will take a fair while to fully bed in. And equally with our clients, there is a need to bring our clients into this. Some clients will have experience, and many clients are desperate to use this, and that's probably the thing I would highlight. In the last few weeks, I've had a significant number of queries from major clients who are wanting to explore the adoption of these processes. And the difficulty we face at the moment is that we have a 2 or 3 tier system where only certain classes of documents are being used for e-signatures, whereas actually most clients are really want to adopt them wholesale. And the other thing I'd flag in this setting is the need to do dry runs. And I've been doing test bed sessions for our clients, which are taking a couple of weeks to complete, where we will do test documents back and forth to make sure that their processes are adequate. And then lastly, I would make special mention of non-Companies Act bodies, corporates, so local authorities and other public authorities and the like, many of whom are struggling to execute documents in the current circumstances because they execute by way of common seal. They are all desperate to move towards e-signatures, and I'm aware many of them are. But that will necessitate, in some cases, special changes to their constitutional documents and governance policies. Those steps are not straightforward and actually present potentially a further barrier to widespread adoption in that setting. It's likely to require specialist legal advice on a case-by-case basis, and also ratification by the relevant boards. So there's lots to do in the kind of admin sphere of this. And as I say, we are a conservative bunch. Change is generally slow and incremental, and this is a fairly seismic change. So we have to be careful at the speed we progress, I think. We need to establish solid and flexible processes that accommodate the needs of all stakeholders and adequately educate all of those involved. I think, at the end of the day, there is a human element here. We need to ensure that the needs of the human beings in the background are accommodated. I think that's probably the simplest way to describe it. So next, I will hand over to Siobhan, who I think is online, who's going to talk about who pays. So Siobhan Hayes from Reed Smith next. Are you there, Siobhan?
I am here. Thanks very much,
Hello.
Tom. Cheers. And the question that I'm just looking at today is whether there could be a barrier for use created by the cost of e-signatures if we move to qualified e-signatures, which I know there are a lot of really positive reasons for doing this, but I think costs are an issue, and you've begun to get a flavour, if you weren't aware of it already, you've begun to get a flavour of the complications that we're facing as law firms, and those complications, of course, lead to costs being incurred, and there are the very obvious direct costs of using electronic signature platforms, and so there will be for a qualified electronic signature platform. There'll be a license fee, an upfront fee for setting up the platform. Now, what we're expecting is that that's likely to be somewhere between about £5,000 and £10,000. The costs will vary depending on the number of signatures and the package that you negotiate with the electronic signature providing platform. So there's that direct fee, and it's unlikely that you can recover that direct fee as a disbursement in any of the bills that you would want to issue your clients. It's not something you've directly incurred in the matter. It's a cost, but it's not a disbursement. And my worry about that is lower margin businesses, not some of the big commercial firms represented here, but that lower margin businesses might struggle therefore to even consider moving to an electronic signature platform that will enable them to use it for qualified electronic signatures. And then we have got the direct costs of actually getting a qualified electronic signature. We're thinking the evidence we've got at the moment is that that's £3.50 plus £13 worth of ID verification. Well, it doesn't sound too expensive, really, does it? But remembering that we don't just do one of these at any one time, and that the person who is controlling the e-signature process sets up the signatures for all the parties to the transaction. Now, if we're just going to do 200 registrations with qualified electronic signatures in a month, and we just have 2 signatories to those documents, then we'll spend £5,400 a month getting that done. But that's £64,800 if we do that each month of the year. And whilst we might just manage to attribute and recover a disbursement cost for our own clients, we certainly won't recover that cost for the signatures of any other parties to the transaction where we're not retained by them. So you've got a direct cost to the party controlling the signature envelope. On top of that, you've also got indirect costs to consider, and the indirect costs are around setup, as well as paying the license fee. We have to, in firms like ours, we have to involve our IT departments for backup. We might have to involve risk and compliance. The property lawyers will have to work with the lawyers setting up e-signatures in all the other practice groups, and possibly coordinate internationally so that we don't all run adrift of practice. That's a lot of central time and effort. And then you heard very clearly from Tom just now just how much you have to do if you want to take electronic signatures on board seriously. And then for qualified electronic signatures, we'll be writing a whole new set of manuals and procedures and adjusting our processes in order to be able to do that. So it's a huge amount of effort, and a huge amount of personal effort involves automatically cost to the business, most of which isn't recoverable. So I'd like to hand over now, and I think the next speaker is going to be Marcos.
Thanks very much, Siobhan. I'm going to start with a confession. I am a fraud. We've come to the e-signing party really late. In fact, so late that we're not in fact using e-signing for conveyancing documents at all. And what we found that even as a fairly large business, and we're talking about 400 lawyers and 700 staff, just the grappling with the technology and getting people trained in how to use it properly is a massive challenge. And the truth is that we're unlikely to be alone in that. If I tell you that we are roughly around about number 60 by turnover in the UK, and we haven't got on board with it, all the other speakers that you've heard go before me are all at firms that are larger than me. There are literally thousands of firms behind us in the queue who are even further back in that journey about even being able to migrate to simple electronic signatures before we move on to anything any more complex than that. Conversely, despite being only number 60 by turnover, we are also number 60 roughly by Land Registry account size. So the number of registrations that we actually submit in a year to the registry is about our size nationally. So it's a decent chunk of registrations, and we can't yet get onto that train with e-signing fully, or at least not in the way that you've heard described by some of the other presenters. What are our challenges? The first one is really technology itself, configuring software. We are a DocuSign user. So as soon as practice guidance came out saying, yep, you can use e-signatures, I got on the phone to my colleague and said, great, look, we can deploy DocuSign across the firm. How are we with these one-time passwords? And I was told by my corporate colleague, we don't have one-time passwords. You can send a code, but we don't have this SMS functionality on our DocuSign account. It turns out that it's not in fact a standard feature with DocuSign because they buy it in from a third party. So we've had to spend more money and we've had to retrain and change our systems to have a new DocuSign account, even to access that one-time password for signatories, let alone the issues that you've already heard with witnesses. We tried to look elsewhere. We looked at hybrid providers. So one of our search companies is InfoTrack, who I know are another big Land Registry customer. They've developed a quotes e-signing solution. We had a look at it. We had a very nice demo from their presenters, and we said, actually, it still doesn't do all the things that we need it to do. And they are a software house. They don't market, they don't sell any product themselves. They advertise themselves as a platform to join other entities, but even they're struggling to try and meet some of the technological constraints around the registry's requirements and how we balance confidentiality and lots of other issues. I'm going to digress from a moment about technology and the challenges with it. My other day job is that I'm a football coach. I work at a grassroots football club. I coach kids from about 4 to 18. Last week, in Mr. Johnson's announcements that we were all going to be locked in our houses and we had to leave the pub at 10 o'clock, he did announce that you could continue to provide sports facilities. Great news. We got an email within the hour from the FA saying, by the way, as of this weekend, you are mandated to provide the NHS track and trace QR codes at all of your pitches. So we had about 4 or 5 days to deploy this. And this is across the country. I'm not just talking about where we are in Suffolk. Within that 4 or 5 days, we discovered that about 15 to 20% of the people who turn up at our football games literally can't even download the app. Never mind work it, figure out what a QR code is, point their camera at it, get it to log. So we are still there with bits of paper, writing down names and contact numbers and how many people are in the party in case there's ever a breakout. And that's a practical example. It's got nothing to do with technology or the Land Registry, but trying to push through change really, really quickly often just leads to you going backwards even faster because there are some that can do it, but there are a significant number that can't. The second one that in terms of a challenge has been training users. Putting it bluntly, and I speak as a lawyer at this point, lawyers don't engage with training unless they have a burning platform, to use the expression that my L&D team call it. Unless it is mission critical, it stops them doing their job, they won't engage with it. And to take the example, we're all on a video call now. We use WebEx as our corporate system. Prior to lockdown, we had about 80 average users regularly engaging with that system. Within 3 weeks of lockdown, we had that total up to 400. And our IT and support teams spent nothing but 3 weeks solid training lawyers in how to use WebEx and how to set up virtual meetings and how to engage with Teams and Zoom and 101 other platforms. To now ask them, having been wedded to their bits of paper for a very, very long time, to say, actually, we're going to take away all your bits of paper and your quill pens, and we're going to ask you to stick it through a system, unless there is that client demand, and we are starting to see that in some corners, they're not going to engage with it. And that third limb of challenge, funnily enough, is around clients. It depressed me to read a recent survey, funnily enough, that OpenReach put out. And it turns out that where I am in humble Suffolk is pretty much one of the worst performing parts of the country for IT and internet connectivity. It turns out that 10% of the general population of Suffolk have literally no internet connection at all. That's mobile or landline. They have no connection to the World Wide Web. So for them, being able to offer an e-signing platform, however great that sounds, is just not practical. They are exactly the same guys who can't use that NHS COVID track and trace app because they don't have a smartphone, or they don't have an iPhone that's up to date. So solutions, how do we solve those problems? Well, listen to me, you know, the cautious lawyer telling everyone to backpedal and take it a little bit easier. For me, it's about keeping those existing channels open. Nobody's expecting that we're going to move to QES overnight. But bearing in mind that we've had 17 years of the Land Registration Act, which has enabled e-signatures, the movement from Section 91 of the Act to where we've been, it's all been kind of concertinaed into 8 weeks at the end of it, where we've had acceptance of Mercury principles, and then we've had e-signatures come along behind that. It's going to take time to move that dial significantly. I'm delighted to hear there are firms on the call who are embracing it and ready to go and got their tech in place. For some of the rest of us, you know, it's give us a chance. And certainly where I am in my part of the world, we are a long way ahead of our local competitors. And even having a meaningful discussion about e-signing with another law firm is likely to be met with blank faces. So I think it's important to keep those alternative channels available and open. I suspect that realistically, it's going to be a process over months and years before you see that wholesale adoption. I'm certainly not resistant to the digital revolution. I've got my smartphone. I can even run some of the apps on it. I could download the track and trace one. Am I ready for e-signatures? Probably not. And it's going to take me a while to come along on that journey. It's going to take other firms even longer to invest in the manpower and the technology and all of the support infrastructure to make that a deliverable possibility. Anyway, the good news is I'm going to stop at this point. You've heard enough about bleating lawyers, blaming the world and its wife for all of our ills. It's probably time to give you guys at the Land Registry a chance to respond and to give us your thoughts. So I'm going to hand over at this point to Robin Malpass. Robin, hopefully you're still there.
I am, thank you.
Excellent.
Perhaps we can pick up on one or two of the points raised earlier on, particularly Catherine's points about how we use witnessed electronic signatures in the Q&A. I would just like to say two things before I speak, and I'm not going to speak for long because I think it's really important that we do have a Q&A and we can do our best to answer your questions. I actually agreed with about 95% of what's been said on this call today. I think the only area where there may be some difference of opinion is around two-factor authentication. What I would say about witnessed electronic signatures, and it's the only thing I'm going to say at this point about witnessed electronic signatures until we get into the Q&A, is we're only 2 months in. we developed the practice very, very quickly. We know that that practice will evolve. We also know that witnessed electronic signatures are going to be around now for quite a long time. And just picking up on what the last speaker said, this is not a quick fix. Yeah, we've had this around for, is it 17 years that this has been something that we've been able to do, and all of a sudden we're doing it. So we just need to be realistic about the pace at which people can move, and we absolutely get that point. But what I would say about the difficulties with platform providers is that we have had extensive discussions with them, and they know what our requirements are. They know why our requirements are what they are, and they have either adapted their service or will be adapting their service to make sure that the requirements can be more easily met. One thing to reflect on here is that witnessed electronic signatures are new to the platform providers as well, because most of the signing platforms hadn't contemplated the execution of deeds when designing their products. And so we're all going through this change together, and it's events like this that help us to strengthen that togetherness and move forward together. But I'd just like to say a few words, and will refer to my notes to make sure I don't miss anything that's really important about the future. We do think that longer term that qualified electronic signatures will provide a more secure and convenient option for conveyancing, but the question of price, as has been discussed on this webinar already, is something we are also concerned about. And what we're saying to potential QES providers is, for this to become something that generates mass market appeal, it has to be at a realistic cost. And of course, that's something that's completely outside the control of HM Land Registry. But this is the strategy that we are adopting in order, we hope, with the support of the legal profession, to steer this forward. We want to make it possible for conveyancers to be able to rely on Section 91. It offers a different legal framework and crucially removes the need for a witness. But the ID processes within qualified electronic signatures are still developing, and their use by consumers is untested in this country. So there's a lot of uncertainty out there about how qualified electronic signatures would work in practice, aside from the cost. But our intention is to work with the sector to bring them in as soon as is realistically possible. But our expectation, as I've already said, is that they'll be used alongside witnessed electronic signatures. Now, at some point in the future, we will need to think about our options, because, as I've said, our preferred option longer term would be the qualified electronic signature, but that's just not on the table at the moment. We would support any initiative that involves the safe use of electronic signatures, whether it's witnessed or qualified. And in the case of qualified electronic signatures, also bringing into play Section 91, because we think that is something that would help everyone longer term. At this point, we're now getting close to having draft practice guidance for qualified electronic signatures. And we're also working on the statutory notice that would be required, that will lay down the conditions that would be relevant. Now, the important thing to say about the conditions here is that qualified electronic signatures are regulated. And so the work that we're doing at the moment is about understanding the risks associated with qualified electronic signatures, and also exploring how we can adapt our own systems to make them machine readable. So there's lots of work going on within the Land Registry. But the key point, I think, for this forum is that as soon as we've got to a point where we've got some drafts, we're going to publicise them. And as we have with witnessed electronic signatures, we will adapt our practice and indeed, if necessary, the statutory notice to reflect feedback that we receive, because this is new for us as well. Although some of us have been around electronic conveyancing for a very long time, technology has moved on massively. And so these are exciting times, but we need to proceed with care. I do think that even after we've published a draft of our practice and the supporting statutory notice, it's going to take platform providers some months, I think, to get to grips with what will be required. So I think this is something that will progress into the new year. And at the same time, I hope that witnessed electronic signature take-up will increase. And then just finally, very quickly, a vision of the future, digital conveyancing. An electronic signature is one of the key foundation stones of a truly digital conveyancing process, but there are other elements that we're also working on at the moment. Digital identity checking, digital deeds, and digital land registration processes. All of those things put together, and you're getting to the point where you have truly digital conveyancing, and that's our vision. And that's all from me. Thank you.
Thank you, Robin. Very, very informative and helpful explanation of your future plans. And I'm hoping, as you say, that we can explore some of that thinking in this open forum Q&A. So we were down for 25 minutes. We've got at least 15, so hopefully we can get some questions coming in. The idea of the forum is very much to question not only aspects of the Land Registry's approach, but also the way that the legal profession is responding itself to the Land Registry's initiatives. So it's not only an opportunity for us to ask the Land Registry about why they're doing things, but also to allow the Land Registry to explain their rationale. And it's very much a dialogue between us so we can understand where each other is coming from. Now, I've got some questions for each of the speakers, because I'm not only going to ask them of the Land Registry, I also intend to tax some of our other speakers on what they've said. But most particularly, I want to hear from those joining the call today. So obviously, most of you are aware of the Teams functionality. You can see you've got the chat box. If you look at the top of your screen, you've got the conversation, and you've got the bottom right hand corner, you've got type a new message. So if you've got a question, please type a message in. If you want to ask the question verbally, there is again at the top of the screen a hand, and if you click on that, I will see if you've raised your hand and I can call upon you to ask a question. Some of you are described as UU, so you're pretty anonymous, so I might just have to somehow work out which the relevant UU is. But please start firing your questions now. We've only got a short time frame, but I'm going to kick off with a question for Robin, just picking up on something that he mentioned previously. Your draft something on QES, is this going to be a sort of consultation like the one you put out for the witness e-signatures? Because in that context, I think we all felt that it happened very, very quickly. It was fantastic that you were responding to it, but you kind of only gave us 2 or 3 weeks really to get our ducks lined up. And I wonder, because there are probably a few more hurdles to scale with QES, whether or not you see it more as a kind of, here it is, we'll think about it, look at it, but it's not going to be rushed on you. Robin?
The short answer is yes. We did what we did because that's what people were asking us to do. We were in the middle of a global pandemic crisis, and we were trying to find ways of helping people. The whole way that we introduced both Mercury and witnessed electronic signatures isn't the traditional way of doing these things. I was worried at the time that we were not giving people enough time to really think about what we were trying to do, and that is why we're having events like this, and our door is open for people to come and talk to us about the problems they're facing as these processes evolve. And so, yeah, absolutely, I would envisage this as a much more steady state consultation process. Aside from anything else, I think that what we're going to be producing will be simpler to follow. And the idea is that within the statutory notice, we will lay down the legal conditions, and they are principally around the requirements in section 91. My cat is keen to join in. I can only apologise for that. She does do this all the time.
Is she an expert on e-signatures?
She's got more knowledge than me, probably, because she's sat through most of it. But the point is that the statutory notice will lay down the conditions, the legal framework in which section 91 operates, and the guidance will then be more explanatory, explaining what are the reasons for having to time and date a document, and what are the reasons for making sure you use a qualified electronic signature if you want to invoke section 91. So it will be a much more traditional, considered approach to both to the consultation and the way in which the guidance is structured.
Okay, I've got a question from Siobhan Hayes. She's wondering how many witnessed electronic signatures the Land Registry have seen since they were permitted.
Now, here's the deal. You would think I would be able to answer that question. Unfortunately, I can't. And the reason that I can't is that because we introduced it so quickly, which was the right thing to do, we didn't build in a mechanism for counting the cases as they come in. We know we've not had that many. We've had some, but I honestly can't give you a number because we were so focused on making sure we introduced the opportunity for people to use electronic signatures. We didn't actually have the time to build in the audit ability to count, and that's something we're currently doing. So not that many, but I can't give you an exact number, I'm afraid.
And linked to that, presumably you don't know what, if any, issues across the board have arisen because you don't have that sort of test reading to see.
So we do know about the issues because what we've done is we've established a small team, and there are 3 members of that team around this call today, Abby, Leslie and Patrick, who are basically dealing with issues that caseworkers encounter so that the issue resolution is centrally controlled.
Okay. I've got a question about QES, and I'm slightly concerned about, you've talked about it will be a considered introduction, but ultimately where I think we would want to end up is that the Land Registry is in a position to guarantee that the vast majority of the public, and I'm thinking here Marcus's part of the world, will readily be able to use the new QES, certainly at least as well as the witnessed e-signatures, within a defined period. And to get to that, how would the Land Registry, what metrics would the Land Registry use to gauge whether or not we're in a position where we can say, well, we're going to go with QES, we're going to keep the witness e-signatures going for a time period, but then we're going to know a point at which we, stop permitting the witness e-signatures, or maybe we say, we carry on with the witnessed and maybe even the Mercury ones for the next couple of years, because why do we have to turn it off? I mean, I acknowledge that obviously you will hopefully perceive that the QES is better in terms of fraud prevention, but ultimately, based on the requirements you've set down for the witnessed process, you would feel comfortable allowing that to continue for the foreseeable.
Yeah, I mean, the way I would encourage practitioners to go through the pain of getting set up with a signature provider to use witnessed electronic signatures. The way I describe it, Warren, is a mixed economy approach for, I think, some years to come. I wouldn't like to say how many years, but I can't see qualified electronic signatures overtaking and burning out witnessed electronic signatures in the very near future. And one of the reasons for that is their newness. It is a different way of doing things. I think there is work to be done, as I said in my brief presentation, around ID checking. That has to become much easier to use a qualified electronic signature. People have to gain confidence to be able to use them. So, the Land Registry isn't in the business of prescribing a particular way of doing things if that isn't what our customers want. What we're trying to do is give a steer as to what we see as the long-term safest option. But I see this mixed economy approach, witnessed electronic signatures and qualified electronic signatures being around for quite some time.
Thank you. Roy Perrott has raised his hand. Can you ask a question, please?
Yes, thank you. It's a question for Robin or for the rest of the Land Registry, and it touches on a point that Catherine made very eloquently near the beginning of her presentation. I just wanted to mention it again in case it's been overlooked by the subsequent discussion. And that is the Land Registry's requirement for application for witnesses. This is going to be problematic for the reasons that Catherine mentioned. I think there's a danger that we might be letting the tail wag the dog here. Just because the technology might exist to enable 2FA for witnesses, although in fact DocuSign don't currently allow it, is not necessarily a reason for having it. And in the world of wetting signatures, this is not, of course, a layer of security that you would have. So I'm curious as to why the Land Registry wants to introduce this, knowing that it is going to potentially be a barrier to our transactions proceeding.
The answer to that is that we believe that we know that it is a standard security feature within the authentication of a signatory. We knew when we were laying the requirement out that some of the leading signature providers don't currently offer 2FA, and that is why we've been engaged in extensive discussions with them to encourage them to make the changes they need to make to include 2FA for witnesses as well. Just on a general point about legality, as the Law Commission acknowledged last year, a registration authority is entitled to lay down conditions under which dispositionary documents will be accepted for registration. And one of the conditions in this case was around the security of the signing process. And I understand that that has caused real difficulties for some people on this call. I would say two things. We're only 2 months into witnessed electronic signatures, and we have been having and will continue to have a dialogue with the platform providers. They understand what is required, and my understanding is that all the leading players are adapting their services to accommodate this requirement.
You okay with that, Roy?
Partially, yes. I mean, it has answered the question, but I think it is important, Robin, to realise that document providers, this is just a small part of their business. We're dealing with multinational companies, American companies, such as DocuSign, and they're not going to be terribly swayed, I would have thought, by the Land Registry's influence. So we have to recognise the commercial factors here as well. That you can put pressure on them, but ultimately it's whether there's a sufficient business case for them to make these changes. And the DocuSign, as I understand it, is quite a difficult process for them to engage in.
For those others on this call, are there any other sort of magic solutions to the current witness e-signature process that you would want to put to Robin to facilitate the witness e-signature process? So we've obviously talked about the witnessing side. Are there any other particular points that you'd like to flag with Robin now? Anybody on the call, anybody raising their hands, now's your opportunity to tell Robin points that you think would really help with utilising the witness process. I mean, one point that does seem to cause quite a lot of issues with clients is who is controlling the process, who is controlling the signing process. We often have comments that you've got an in-house lawyer at a client and they want to run the process. And there's been a little bit of murkiness around, well, if they are a solicitor with a practicing certificate, it seems to be that they, as the in-house lawyer, would be able to control that process. But I mean, is that your reflections on that, Robin?
Yeah, in our discussions with the signing providers before we published the draft guidance, they all the big players provided us with demonstrations of how the signing process might work, and they all showed us that an individual was effectively controlling the process. And all that we've done is try to reflect what we believe is a standard operating procedure. We're not really, if there are other ways of doing it and people are using other ways of doing it, then we can look at the guidance and see if we can accommodate those other ways of doing it. What we're concerned to ensure is that a conveyancer is involved in the signing process to such an extent that they can either certify or give assurance that the signing process that's laid down in the guidance has been followed. That's our principal concern. And if we can make tweaks to the guidance that would facilitate particular situations, then we would be, we would be happy to do that. But one of the challenges that we also get, and this has been alluded to on this call this afternoon, is that not everyone is as au fait with the process. And some people are saying to us, please tell us less about what we've got to do, whereas other people are actually telling us, please tell us more about what we've got to do. And what we're trying to do is strike the right balance.
Yeah, okay. I've got one quick question for you, which again is one that's been doing the rounds between us, which is documents that you never see. So, for example, if you've got a lease that's a registrable document, and you've obviously got the part executed by the landlord by e-signature that has to comply with your requirements, what about where you've got the counterpart executed by the tenant that you never see in that situation? I mean, bearing in mind that we have the concept of mixed use, mixed signing documents where one can be wet ink signed and one could be e-signed, or one could be mercury signed and one could be e-signed. Do you actually care about the tenant's part that you never see?
I've not really thought about that. I think the answer to that is a very simple. My approach would be, and this is what I would say to anyone who's getting into the world of witness electronic signatures: try to keep it as simple as you can. If you can avoid mixed signing, you'll make your lives a lot easier. But in the case of a lease where the document that's presented for registration is the lease that's been signed by the landlord, that is the document that we're seeking assurance in relation to. If there's a counterpart that's been signed by the tenant, we're not going to ask questions about how that's been signed unless there was ever an issue about whether there was as does sometimes happen, where, for example, there is a discrepancy between the lease and the counterpart, and then you've got to figure out who did what.
Okay.
But no, as a general rule, the guidance is intended to guide conveyancers in relation to the document that's being presented for registration, and it is only substantive registration documents that the guidance relates to.
Yes.
So I think I've given you a straight answer on that.
No, that's a really good answer. Thank you. Siobhan, just to come up with a comment, Siobhan Hayes, on two-factor authentication for signatories and witnesses, she says that we're starting to see some large clients refuse to provide signatory and witness mobile phone numbers because of personal data reasons. And I mean, that I think is an issue that I think we're seeing with quite a lot of clients and other parties who are concerned about the sort of GDPR implications of all of this, and requiring the SMS authentication from the platform can cause issues. I mean, was that something that was a factor for you when you were considering two-factor authentication?
Yeah, I suppose, we understand that there will be people out there that aren't comfortable with providing personal details, and it was a factor for us, Warren. And when we were trying to figure out what form of evidence does the Land Registry need in order to satisfy itself that the document is a valid witnessed electronic signature document, we shied away from asking for the audit report, completion statement that the signature providers provide, just for that reason. We were concerned that we would end up holding a whole host of personal data that this frankly is none of our business, and that could then be accessed by other people. As for people's willingness to disclose their mobile phone number, I can't really answer that. I would go back to what I said earlier, that actually two-factor authentication is commercially a very, very common way of verifying the identity of an individual.
Yeah, thank you. Right, we're at 1:32, so it's 2 minutes over our 1 hour. So any final comments from the members of the panel, including Robin?
I wondered if I could ask one question.
Yeah.
I did have my hand up earlier, but I thought perhaps we'd run out of time. I would just be very interested to hear from anyone who's been engaging directly with platform providers about the changes that they're being asked to make, particularly the point earlier about how much influence has the Land Registry got. Actually, we're finding that we've got quite a lot of influence. Some of the most senior people in the big players have been sitting down with us and talking to us, and And so they are actually very interested in working with us. But I would be very interested in hearing, not necessarily on this call, but perhaps through you, Warren, if anyone's had any experiences of the engagement they've experienced with signature providers, and perhaps without naming them, we would be interested to hear how colleagues have been getting on in trying to move this forward.
I guess maybe one of the important things to convince them is actually that although QES might be on the horizon, actually they probably should be investing some time and resources into sorting out the witnessed e-signature.
And Warren, that has been at the heart of our messaging, and the buzz phrase that I'm using is the mixed economy approach. We see witnessed electronic signatures, for reasons that have been really well explained on this call, as being a part of everyday life for some time to come, and we would encourage everyone to embrace the technology and see how they can make it work for them.
Fantastic. So our time is up. I'd like to thank all of our speakers for your excellent presentations and sharing your thoughts on this critical area of legal practice. Many thanks in particular to Robin and the Land Registry for agreeing to take part. I hope everybody found it helpful in terms of thought processes being explained and obviously understanding the Land Registry's plans for the future. And I hope the feedback that people have given to Robin and the Land Registry today is helpful and can assist with developing your approach towards e-signatures. And we want this type of forum to be a regular occurrence where we can share ideas on Land Registry practice and future developments. And I know the Land Registry has its own forum, but as you can see from the number of people we had on this call, over 40 people, it does give an opportunity for a wider spread of views. And I personally, and I've always believed this, the Land Registry working together with the legal profession on initiatives in a sensible and effective way ensures that we get outcomes that addresses the Land Registry's concerns, but also in a way that is practical for property professionals, other stakeholders in the property industry, and in particular, our clients. And also, can I thank everybody who joined today, the audience, for your excellent contributions and what I think was an extremely stimulating session. As Catherine said at the beginning, this session has been recorded and the recording will be circulated shortly. So many thanks again to everybody for joining, and I hope you enjoy the rest of your day. Thank you.
Thanks very much, Warren.
Thanks, Warren. Look
Thanks,
forward
Warren.
to catching up with you again soon.
Cheers. Thank you.
Thank
Thank you,
you.
everyone. Bye-bye.
Thanks.
Catherine, still on the call?